They called her a gold digger until the will revealed who paid the debts who paid. The words didn't just spread through the probate hallway, they followed her like a verdict before any judge ever spoke, as she stood there quietly holding a thin legal folder marked only with a hospital payment record and a sealed estate envelope that no one in the room had dared to open yet. The envelope sat on the lawyer's table like a neutral object, but everyone knew better, it wasn't neutral. It was pressure sealed in paper. The younger white American woman didn't react to the whispers, didn't respond to the sideways glances, didn't correct the label being placed on her in real time. Around her, family members of the deceased spoke in lowered voices but sharp tones, repeating the same idea: she didn't belong here, she had no real claim, she was just someone who showed up late. And yet, sitting across the room, the quiet white billionaire mentor observed everything without moving, his presence understated, his suit dark and perfectly tailored without a single visible logo, the kind of wealth that never needed attention because it already controlled systems that others misunderstood. He wasn't here for emotion. He was here for structure: who paid, who signed, who carried responsibility when no one was watching. On the lawyer's table, the sealed envelope remained untouched, labeled in faded ink as an estate instruction file combined with debt allocation records. That combination alone was enough to shift the meaning of the entire dispute, because in American probate systems, inheritance is never just about what is given, it is about what was already taken care of financially before anything is distributed. The family believed they were here to divide assets. But the file suggested something far more uncomfortable: someone had already been covering the estate's burden quietly, long before anyone argued about ownership. The younger woman stood slightly apart from the main group, her posture calm, her expression controlled in a way that made people misinterpret her silence as weakness. She was not trying to defend herself verbally, because she had learned something most people only realize too late in financial disputes. In legal systems, speech is temporary, but records are permanent. And somewhere inside that sealed envelope were records that would decide whether she was an outsider or the only person who had been financially maintaining parts of the estate no one else wanted to acknowledge. The attorney entered the room with the file but did not open it immediately, instead confirming procedure, confirming signatures, confirming that the document had been properly sealed under estate protocol. That pause made the tension worse, because silence before evidence is always heavier than argument after it. One of the relatives finally spoke, suggesting she had no authority to even be near the discussion, implying her presence was emotional rather than legal, that she was confusing proximity with ownership. But the billionaire mentor, still silent, watched the way the attorney handled the file and already recognized the pattern: when people don't understand financial structure, they try to replace it with social hierarchy. They assume louder voices mean stronger claims. They assume family status replaces documentation. They assume visibility equals ownership. None of those assumptions survive probate review. The younger woman finally looked toward the sealed envelope, not with anticipation, but with recognition, as if she already understood what it contained. Because she had seen fragments before: hospital billing records, bank transfers tied to estate accounts, payment confirmations that no one else had bothered to trace fully. Small pieces of financial responsibility that did not fit the narrative others were repeating about her. And yet, those fragments always pointed back to one question that now hung over the entire room: if she was not involved, then who had been paying the debts that kept this estate stable while everything else was falling apart? The billionaire finally broke his silence with a simple observation, not directed at anyone in particular, but landing with weight in a room full of assumptions: in financial systems like this, the truth is never hidden, it is just ignored until the documents force it to be seen. And as the attorney placed his hand on the sealed envelope, preparing to open it for the first time in front of everyone, the entire room unknowingly crossed the point of no return, where opinion would no longer matter and only records would decide what kind of story this actually was. After the sealed envelope was placed on the attorney's table, the entire atmosphere shifted from accusation to waiting, but in a courtroom environment like this, waiting is never neutral, it always carries pressure. The younger white American woman stood near the edge of the probate office, surrounded by a mix of family members, estate lawyers, and distant relatives who all seemed confident in one shared assumption: she was out of place here. Outside, through the courthouse windows, everyday American life continued: cars pulling into the parking lot, people checking mortgage statements on their phones, others walking in with insurance folders, credit card disputes, and small business paperwork. But inside, everything had narrowed down to one object on the table, the sealed estate envelope marked with debt allocation and will instructions. Across from her, the quiet white billionaire mentor remained seated in the same position he had held since the beginning, calm, observant, and detached from emotional noise. He didn't look like someone involved in a family dispute. He looked like someone who had seen enough financial systems to know exactly where truth usually hides, inside paperwork nobody reads carefully until it is too late to ignore. The younger woman, however, looked nothing like the image the others were projecting onto her. She was dressed simply, no visible status markers, no attempt to present wealth or influence. That simplicity was exactly why she was being underestimated. In environments like this, American probate hearings, estate disputes, and informal financial confrontations, appearance often gets mistaken for position. But she understood something different. While others spoke in assumptions, she had spent time reviewing actual documents, bank transfers tied to estate accounts, mortgage statements showing irregular but consistent payments, hospital billing records with matching transaction IDs, and email confirmations referencing financial responsibilities that no one in the room seemed eager to acknowledge. These weren't emotional claims. They were financial footprints. Earlier that week, she had quietly organized copies of those records in a simple folder, nothing dramatic, just structured proof. She didn't present them loudly. She didn't argue. She simply kept them aligned in chronological order, as if she already understood that in situations like this, truth doesn't win by volume, it wins by sequence. Meanwhile, the family members around her interpreted her silence as uncertainty. They assumed she was passive, maybe even confused about her role in the estate. One relative whispered that she was only present because of emotional attachment, not financial relevance. Another suggested she was trying to insert herself into a process she didn't understand. But none of those assumptions matched what was actually sitting in the financial records waiting to be reviewed. The billionaire mentor finally shifted slightly in his chair, not to intervene, but to observe the reactions in the room. He had seen this pattern before in boardrooms and legal disputes across the United States. When people cannot immediately explain financial responsibility, they default to social interpretation. They confuse familiarity with ownership, presence with authority, and emotion with entitlement. That confusion always breaks down the same way when bank records, deeds, and payment histories enter the conversation. Outside the courthouse context, the world continued functioning on the same invisible financial rules. Suburban homes were tied to mortgages most people didn't fully read. Small businesses were running payroll based on contracts few employees had seen. Credit card balances, insurance premiums, and business accounts were all moving quietly in the background of everyday life. And yet inside this room, those same systems were about to be re-examined under legal scrutiny. The attorney returned to the table and placed his hand once again on the sealed envelope. This time, the silence felt different, not like waiting, but like anticipation before correction. Because what was inside that envelope wasn't just a will. It was a debt allocation record tied to estate responsibility, something that could reshape everything everyone thought they knew about who carried the financial burden during the final years of the estate's instability. The younger woman glanced at the envelope briefly, not with anxiety, but with recognition. She had seen fragments of its contents before in separate documents, mortgage continuity logs, partial payment acknowledgements, and structured references to financial contributions that never matched the public narrative being repeated about her role. Those fragments always pointed toward one unresolved contradiction: if she wasn't responsible, then why did the financial records consistently show her name connected to the payments that kept the estate stable? That question hung in the air as the attorney prepared to open the file, and in that moment, the biggest lie in the room, who actually paid what, was about to be tested against the only thing that matters in systems like this: written proof. In the probate office, as the sealed envelope sat 1 inch away from being opened, the real conflict in the room was no longer about inheritance, it was about perception versus proof. The younger white American woman stood quietly near the edge of the table, her posture calm, her expression unreadable, while the family around her continued to project a version of her identity built entirely on assumption. To them, she was the outsider who didn't belong in financial decisions of this scale. To them, she was that simple one, the quiet one, the one who must not understand what was really happening inside the estate. And that belief, more than anything else, was what created the tension in the room. The quiet white billionaire mentor remained seated a few feet away, observing without interference, his attention not on the people, but on the structure of what they believed. Because in his experience, financial conflict is never about emotion, it is about misunderstanding the difference between what looks true and what is documented as true. And in this room, that gap was about to be exposed. The most dangerous belief in the room was simple but deeply rooted. People assumed that appearance equals financial position. They believed that dressing modestly meant lacking wealth. They believed that speaking less meant knowing less. They believed that being questioned meant being weak. But in reality, none of those assumptions survive contact with records. The younger woman did not argue because she didn't need to. She had already done something far more powerful than arguing. She had organized proof. Bank statements showing consistent financial activity tied to estate obligations. Mortgage records showing uninterrupted payments during periods when others assumed instability. Hospital billing confirmations tied to actual transfers. Email chains that quietly recorded decisions no one else wanted to acknowledge publicly. None of it was dramatic individually. But together, it formed a timeline that contradicted every assumption being spoken aloud in the room. The family, however, continued to rely on a different logic. They confused visibility with ownership. They assumed that living in a house meant owning it, even when deeds and mortgage structures said otherwise. They assumed that being related to someone meant inheriting responsibility, even when legal documents required formal designation. They assumed that a title, CEO, heir, executor, spokesperson, meant actual financial creation or control. But titles are not transactions. And in American financial systems, transactions always outrank narratives. One of the relatives leaned in and repeated what had become the central accusation, that she was benefiting from proximity rather than contribution. That she was emotionally involved, but financially irrelevant. That she was, in their words, present but not powerful. The irony was that they had no idea how many times her name appeared in the actual financial continuity record sitting inside the sealed envelope. The billionaire mentor finally shifted slightly in his chair again, not to interrupt, but to highlight a pattern only he seemed to fully recognize. In situations like this, people don't argue against truth, they argue against the discomfort of realizing they misread it. And misreading happens in predictable ways, looking rich versus actually owning assets, being loud versus being prepared, making monthly payments versus holding real ownership, relying on family pressure versus relying on legal proof, projecting public confidence versus maintaining private records that survive scrutiny. The younger woman's entire position in the room was built on the second column of that comparison, not the first. And that is why she was being underestimated. The attorney paused again before opening the envelope, and in that silence, a deeper question formed, not spoken, but felt throughout the room. How many financial disputes in everyday American life begin exactly like this, where people assume they understand ownership simply because they understand relationships? Suburban homes with unclear deeds. Small businesses with misunderstood payroll responsibility. Estate plan signed but never fully read. Insurance policies activated but never fully understood. Credit cards, mortgages, and bank accounts all moving in the background of daily life, while assumptions fill in the gaps where documentation should be. The younger woman's attention remained fixed on the envelope, not because she was anxious, but because she understood what the next few seconds meant. Inside that file was not just information, it was structure. Structure that would determine who actually carried financial responsibility when no one else wanted to. And as the attorney finally placed his hand on the seal, ready to open the document that everyone in the room had been speculating about but no one had truly understood, the central illusion in the room, who was financially important and who was not, was about to collide with the only thing that ever resolves it, written proof. The attorney finally places the sealed estate envelope on the table, and before opening it, he does something that changes the energy in the room more than any argument ever could. He begins to explain what the document actually represents in simple, legal terms that everyone can understand, because in American probate cases, confusion is often not emotional, it is structural. A will, he says, does not automatically control everything unless it is valid, properly executed, and legally recognized in the probate system. A deed is not a suggestion, it is ownership recorded by law, not by family opinion. A mortgage payment, no matter how consistent, does not automatically equal ownership, it can show responsibility, but not title. Bank records, however, do something far more important, they show who actually carried the financial burden when pressure existed and silence followed. The younger white American woman stands still as he speaks, not reacting outwardly, because she has already lived inside these documents long before they were being discussed aloud. Across from her, the family listens, but not everyone is truly hearing the distinction between perception and legal structure. The quiet white billionaire mentor remains unchanged in posture, watching not the people, but the moment when explanation becomes evidence. He has seen this pattern before. When legal definitions are finally introduced, assumptions collapse faster than emotions. The attorney continues, explaining that a contract is not just paper, it is enforceable power. A single clause can determine financial control, responsibility, or liability. An old email chain, if properly authenticated, can establish authorship of decisions that people try to deny later. A business plan has an origin point in time, and that origin can determine ownership of ideas and structure. A boardroom title does not erase receipts, and payroll records often reveal the real priorities of a business far more accurately than public statements ever do. Fine print, he adds calmly, is where companies either protect themselves or lose everything quietly. Then the process begins in sequence, not drama. The probate file is officially opened. The sealed letter is carefully unfolded under procedural supervision. The deed records are cross-checked against county filings. Mortgage history is pulled and reviewed line by line. Signatures are compared across documents to confirm continuity of responsibility. Bank records are displayed on screen, showing transactions tied to estate obligations over time. The room begins to shift, not emotionally, but structurally, as each layer of documentation confirms what cannot be argued with personal interpretation. The younger woman does not interrupt any of it. She does not need to, because the documents already contain her timeline. The billionaire mentor finally leans slightly forward as the attorney continues, not because anything surprising has happened yet, but because the sequence of proof is now reaching the point where narrative will no longer matter. Outside this room, in everyday American life, these same systems operate quietly. People sign mortgage agreements without reading every clause. Families inherit responsibilities without reviewing full estate files. Employees accept payroll structures without understanding contract terms. Business owners rely on trust instead of verifying documentation trails. And in most cases, nothing breaks until it does, and then only records can repair the truth. The attorney pauses briefly before moving to the final section of the file. He does not reveal it yet, but everyone in the room understands that the next page is where contradiction becomes undeniable. Because so far, they have seen fragments, payments, signatures, references, and acknowledgements. But fragments do not decide outcomes. Structure does. And inside that structure, there is something that has not been fully shown yet, a key piece of evidence inside the estate ledger that connects responsibility, payment history, and legal recognition in a way that no one in the room has fully accounted for. The envelope is now fully open. The pages are ready. And what comes next is no longer explanation, it is exposure. The envelope was finally open, but what came out of it was not a single dramatic sentence, it was structure, layered carefully across years of financial behavior that no one in the room had taken the time to fully connect until now. On the table, the attorney placed the first set of documents, a forgotten will attached to a legal folder labeled Estate Instructions, with handwritten annotations in the margins and a formal signature dated years earlier. Next to it, a sealed letter with an older signature variation, verified by matching bank and legal records. The room did not react yet, because people often do not understand impact until it accumulates across multiple pages. The younger white American woman stood slightly to the side, her posture unchanged, eyes focused on the documents rather than the people reacting around her. She did not look surprised. She looked aligned with it, as if she had already studied this sequence in pieces long before it was assembled in front of everyone else. That difference mattered more than anyone realized. Across the table, the quiet white billionaire mentor observed something subtle but decisive. She was not discovering the truth, she was simply watching it become visible to others. That distinction told him everything he needed to know about her preparation. The attorney then revealed additional materials from the same estate folder. A deed record showing her name linked to property-level responsibility entries. Mortgage history logs showing continuous payments during estate instability periods. Tax receipts tied to estate obligations that had gone unpaid at different points by others. An old ledger documenting financial flows between accounts associated with the estate, carefully tracked but never publicly discussed. Bank records confirming transaction continuity under her financial oversight. Each document was not powerful alone, but together they formed a timeline that contradicted the narrative being spoken about her in the room. And yet, even as the evidence accumulated, some family members still leaned on assumption rather than structure. They continued to believe that because she did not dress loudly, speak aggressively, or hold a visible title within the family hierarchy, she must not hold real financial authority. That assumption is common in environments like this: estate disputes, probate hearings, and family-driven financial conflicts across the United States. People often mistake visibility for control. They assume that the loudest person has the most ownership. They assume that public confidence equals financial competence. But documents rarely support those assumptions. The younger woman finally adjusted her stance slightly, not in response to pressure, but as if confirming alignment with what was now being formally read. She understood something that others were only beginning to realize: financial truth does not need performance. It only needs sequence. The billionaire mentor noticed this clearly. She had not interrupted, not corrected, not defended herself verbally once. Instead, she had done something far more effective. She had maintained records, preserved documentation, and allowed the system to speak for her when required. That is why people like her are often misread in real time. They do not compete for attention, they prepare for verification. The attorney moved on to another section of the file. An old email chain was introduced, showing correspondence tied to financial decisions related to the estate, including references to payment responsibility and coordination of obligations. A business plan draft, partially annotated in her handwriting, was also included, not as a claim of ownership, but as evidence of early structural involvement in financial planning decisions that others now publicly denied. A payroll-style spreadsheet connected to estate-funded obligations appeared next, showing consistency in financial execution rather than symbolic involvement. None of these documents were emotional. They were procedural. And that is what made them difficult to challenge. The family members who had previously labeled her began to shift their reaction slightly, not because they accepted everything yet, but because they were now forced into a space where opinion was no longer enough. Outside the room, life in the courthouse continued as usual. People filed in and out of hearings, carrying insurance disputes, mortgage adjustments, and small claims cases. But inside this room, the structure of one estate dispute was quietly being rewritten by documentation that had existed long before anyone decided to question it. The key insight emerging, though not yet fully stated aloud, was simple but unavoidable: people who understand money do not win by being loud. They win by keeping records, reading terms carefully, and allowing proof to arrive at the correct time, not the fastest emotional moment. The younger woman embodied that principle without saying it. The billionaire mentor recognized it without needing confirmation. And those who had relied on assumption were now facing something far more difficult than disagreement. They were facing documentation that would not change under pressure. But even now, the attorney had not reached the final section of the estate ledger. And what remained inside that final layer of the file was not just confirmation of past payments, it was the part of the record that would determine who, legally and financially, had carried the estate when no one else was willing to accept responsibility. As the attorney prepared to turn the next page, the room unknowingly moved closer to a shift that would no longer be about perception at all, but about consequence. The moment the attorney turned to the next section of the estate file, the atmosphere in the room changed again, but this time it wasn't curiosity or confusion. It was resistance. Because what comes after documentation is often not clarity, but pressure. And pressure, in American probate and financial disputes, is where truth is most often distorted before it is fully accepted. The younger white American woman stood still near the edge of the table, her presence calm but increasingly isolated as family members began to shift their focus away from the documents and back toward her. Not because the records had changed, but because people under financial stress rarely attack the paper first, they attack the person standing closest to it. One relative finally broke the silence, suggesting again that she had no legitimate standing in the estate, framing her involvement as emotional rather than financial. Another implied she had misinterpreted her role entirely, calling her presence in the process inappropriate given her lack of official family title. The phrase gold digger surfaced again, not as a question, but as an attempt to stabilize a collapsing narrative. But in legal environments like this, repetition does not create truth, it only reveals desperation. Across the table, the quiet white billionaire mentor remained composed, watching not the accusations, but the pattern behind them. He had seen this stage many times before. When documents begin to contradict assumptions, people stop arguing facts and start attacking credibility. It is a predictable response when financial structure begins to override social hierarchy. The attorney, however, did not engage with the emotional pressure in the room. He continued reading from the estate ledger, moving into sections that outlined financial responsibility during the most unstable period of the estate's timeline. Mortgage continuity entries. Hospital payment records. Tax obligations covered during administrative delay. Each line reinforced a structure that did not depend on opinion. It depended on transactions. The family's frustration grew, not because the information was unclear, but because it was too clear. It left no room for reinterpretation. One of the heirs leaned forward and demanded clarification on whether these payments automatically implied ownership, attempting to reframe responsibility as coincidence. Another suggested that even if payments existed, they were made out of sympathy rather than obligation, as if emotional motivation could erase financial consequence. But that is where most financial misunderstandings collapse, when people confuse intention with structure. In American law, intention is irrelevant if documentation establishes responsibility. The younger woman did not respond to the accusations. She did not need to. Her silence was not avoidance, it was alignment with a process already moving beyond interpretation. The billionaire mentor noticed this clearly. In high-stakes financial disputes, those who understand the system do not waste energy correcting every false statement. They wait for the structure of proof to complete itself. And that is exactly what was happening inside this room. The attorney then introduced another layer of documentation, annotated contract clauses tied to estate management decisions, showing that certain financial obligations had been formally acknowledged in writing, not inferred. A signed acknowledgement page appeared next, confirming awareness of responsibility distribution across multiple estate-related accounts. A series of bank records followed, showing continuity of payments over time, not as isolated events, but as sustained financial behavior tied to estate stability. The room began to quiet again, not because people agreed, but because they were being forced into a position where disagreement no longer had a financial foundation. This is where pressure becomes dangerous in legal and financial environments. When people feel their position weakening, they often attempt to settle quickly, accept incomplete outcomes, or agree to terms that preserve emotional comfort rather than financial accuracy. They sign away clarity just to reduce tension. They give up ownership just to end conflict. They accept shame-based narratives just to avoid prolonged scrutiny. And in doing so, they lose more than the dispute, they lose structural rights they did not fully understand they had. The younger woman, however, showed no movement toward compromise. Not because she was resisting resolution, but because she was not negotiating perception, she was standing inside documentation that had already been created before the pressure began. That distinction mattered more than anyone in the room fully realized yet. The billionaire mentor finally shifted his gaze from the documents to the people in the room, observing how quickly confidence changes when financial assumptions begin to fail. He understood something most people miss: when truth enters a system built on assumption, the system does not immediately accept it, it first tries to reject it. That rejection phase is what they were witnessing now. But beneath all of it, the estate ledger continued to move forward, line by line, page by page, toward its final section. And what was coming next was not another interpretation of responsibility, it was the structural answer to a question no one in the room had been able to agree on. In a system built on wills, deeds, bank records, and legal obligations, why does the truth always end up contradicting the story people are most comfortable believing? The next page was about to answer that question in a way that no amount of pressure, opinion, or accusation could reverse. The turning point came not with emotion, not with argument, but with the attorney sliding the final section of the estate ledger onto the table and opening it under full procedural confirmation. The room didn't get louder, in fact, it got quieter. Because this was the moment where speculation stopped being useful. The document in front of them was no longer about interpretation. It was about confirmation. The younger white American woman stood exactly where she had been standing since the beginning, her expression unchanged, her hands relaxed at her sides, as if she already understood that truth in financial systems does not appear suddenly, it accumulates, then reveals itself all at once. Across the table, the quiet white billionaire mentor leaned slightly forward for the first time, not because he was surprised, but because the structure of the evidence had reached its final form. The attorney began reading directly from the estate ledger and will combination file. The first confirmation was ownership-related responsibility, the will explicitly named distribution priority tied to debt continuity, not just inheritance. And in that section, the name repeated across multiple entries was not the person the family had been assuming. It was hers. A low murmur started, but it died quickly when the attorney continued. The next section confirmed payment responsibility, hospital debt coverage, mortgage continuity, tax arrears stabilization, all recorded with bank verification entries attached. Each line was backed by transaction IDs, not verbal claims. The ledger did not describe intentions. It described execution. Then came the deed verification cross-reference. The attorney confirmed that while the property structure remained under estate review, the continuity of financial obligations tied to that property had been maintained through her documented payments during probate delay periods. In plain legal terms, she had carried what others assumed had been inactive or unresolved. The room shifted slightly at that point, not emotionally, but structurally. People stopped looking at her the same way, because the financial narrative they had built no longer matched the verified record. The attorney continued. The business-related annex inside the estate file, unexpected to some family members, showed that she had authored sections of a financial stabilization spreadsheet used during estate management, tracking liabilities and ensuring payroll continuity for estate-linked obligations. That detail hit harder than the rest because it extended her role beyond personal payment and into structural financial maintenance. The document did not call her emotional. It did not call her symbolic. It listed her as functional in the financial system of the estate. Across the table, one of the relatives tried to speak but stopped halfway. There was nothing left to argue against in the same way. The billionaire mentor finally spoke, his voice calm, not directed at anyone in particular, but landing with precision in the center of the room. Money gets loud when people lie. Proof gets quiet when it is true. No one responded, because there was nothing to add to it. It wasn't a challenge. It was a summary of what had just happened. The attorney then confirmed the final structural point in the file. Legal authority acknowledgement entries tied to estate responsibility had been formally recorded in multiple documents, including signed financial acknowledgements and validated payment histories. That meant the estate's financial burden had not only been tracked, it had been legally attributed. And the attribution did not match the assumptions that had driven the conflict from the beginning. The silence that followed was not emotional silence. It was procedural silence, the kind that happens when a system finishes verifying what people spent the entire time debating. The younger woman did not react. Not because she was detached, but because nothing new had been added to her understanding of the situation. She had been operating from documentation long before the room caught up. The difference now was that everyone else could see it. The family members who had spoken earlier now avoided eye contact with the file. Not because of guilt, but because the structure of the evidence made their earlier certainty unstable. The attorney closed the ledger slightly, signaling that the verification phase was complete. But what he did not do was distribute conclusions yet. Because in legal and financial systems like this, confirmation does not immediately equal resolution. It triggers consequence review. And that is where the real shift begins. The billionaire mentor looked at the file one last time before leaning back again. He understood what was coming next. Once responsibility is legally confirmed, the system does not argue, it adjusts. Estate distribution recalculates. Claims are reclassified. Assumptions are removed from the record. And every party in the room is reassessed based not on perception, but on verified contribution. The attorney prepared to move into that phase, but paused for a moment longer than necessary. Because everyone in the room understood the same thing now, even if they didn't say it out loud, the question was never about who was accused. It was about who could prove what they had actually carried when no one was watching. And the next stage of this process would determine not just what was true, but what the law would now do with that truth. The legal consequences did not arrive as drama, they arrived as procedure. After the estate ledger was fully verified in Part 7, the attorney submitted the combined will, debt allocation record, and supporting financial documentation into formal probate review, triggering the next stage of legal correction rather than interpretation. The younger white American woman stood quietly as the process shifted away from debate and into enforcement, her posture unchanged, as if she had already lived through this phase long before it became official. The quiet white billionaire mentor remained seated, observing the transition with the same calm focus he had maintained from the beginning, because in his world, this was never about winning arguments, it was about systems updating themselves once proof becomes undeniable. The probate attorney confirmed the first outcome clearly: the document was valid under state requirements, and therefore enforceable in its financial structure. That meant the debt allocation entries inside the estate ledger were not symbolic, they were binding in terms of estate accounting. The judge, reviewing remotely through official filing updates, did not comment emotionally, but acknowledged procedural acceptance of the documentation chain. That alone shifted the entire estate process into correction mode. The next adjustment involved financial responsibility recognition. Bank records, mortgage continuity logs, and tax receipts tied to estate obligations were formally entered into the probate record. This resulted in a recalculation of estate distribution priority, where claims previously assumed by family members were now paused pending verification of financial responsibility alignment. In simple terms, inheritance distribution could not proceed until the system accounted for who had actually carried the estate financially during its most unstable period. One of the immediate legal outcomes was the temporary pause of asset transfer orders. Not as punishment, but as standard probate correction. The court could not distribute what had not been properly reconciled. That included property-related access rights that had been incorrectly assumed by certain heirs. The deed history was reviewed again alongside mortgage continuity records, confirming that financial responsibility and legal access had diverged at key points. As a result, certain eviction-related assumptions were blocked pending final determination of ownership alignment. In parallel, estate financial oversight confirmed that tax obligations had been partially covered by documented payments tied to the younger woman's financial activity, which further reinforced her recognized role in maintaining estate stability. This did not immediately assign ownership, but it legally protected her contributions from being ignored or reclassified as informal support. The estate system, now fully in correction mode, began adjusting distribution terms accordingly. Settlement discussions were formally corrected by the legal team to reflect verified financial contributions rather than family narrative assumptions. The attorney made it clear that future discussions would have to align with documented proof, not verbal claims or perceived family roles. Meanwhile, in the room, the emotional temperature lowered, not because anyone felt resolved, but because the system itself had taken over the conversation. The billionaire mentor finally spoke again, but this time not as commentary, more as reflection on the structure unfolding in front of them. He summarized what the entire process had revealed in simple, practical terms: keep records when others rely on memory, read contracts before assuming relationships define ownership, know whose name is on the title before trusting access, track cash flow instead of reputation, protect signatures because they decide authority, and never confuse approval with security, because approval can be emotional while security is always documented. No one challenged him, because nothing he said required interpretation, it matched exactly what the legal process had just enforced. The younger woman did not react to the corrections being made in real time. Her behavior suggested something important that the mentor quietly recognized: she had not been waiting for validation. She had been waiting for the system to catch up. And now that it had, she was not gaining something new, she was simply no longer being misrepresented. The family members, still processing the shift, were now forced to confront a reality they had not prepared for. Their understanding of the estate had been built on assumptions about visibility, not documentation. And those assumptions were no longer part of the legal record. As the attorney prepared the final procedural steps for closure of this phase, there was one remaining question left unaddressed, not in emotion, but in structure. Because even though responsibility had been verified and consequences had been applied, the deeper issue had not yet been fully articulated in front of everyone. What does it actually mean, in financial systems like this, to be the person who paid when no one believed it until the documents forced them to? That answer would define not just the outcome of the estate, but the identity of the person everyone had misjudged from the very beginning. The probate room did not end with a dramatic moment, it ended with a system correction. After the estate ledger, bank records, deed verification, and tax history were fully accepted into the legal file, the case transitioned out of dispute and into final structural alignment. Nothing exploded. Nothing was shouted. Instead, everything simply settled into place the way financial truth always does once documentation is complete. The younger white American woman stood quietly as the attorney finalized the updated estate record, her expression steady, not because she was unaffected, but because nothing in the process required emotional performance. Across from her, the quiet white billionaire mentor remained still, observing the final administrative steps with the same calm focus he had shown from the beginning. He understood something the room had slowly been forced to accept: power in modern financial systems is not expressed through presence or status, it is expressed through what survives verification. The attorney summarized the outcome in formal language: estate distribution would proceed only under corrected financial responsibility mapping, ensuring that documented payments, verified contributions, and legal acknowledgements were properly accounted for before any final transfer of assets. That meant the estate was no longer being interpreted through family narrative or emotional claims. It was being structured through records, signatures, and financial continuity. And in that structure, the younger woman's role was no longer questioned in the same way, it had already been recorded in the system. The billionaire mentor finally stood, not as a reaction to victory, but as acknowledgement of principle. He looked at the younger woman briefly, then at the remaining documents on the table, and what he represented in that moment was not wealth in the flashy sense, but understanding that money is never just currency, it is documentation, timing, and enforceable structure. In his world, people do not lose wealth because they are weak, they lose it because they confuse perception with ownership, and emotion with legal reality. The younger woman did not speak much, even now. She didn't need to. Her entire position in the story had already been defined not by what she said, but by what she had kept consistent over time: records, receipts, payment histories, signed acknowledgements, and structured financial behavior that no one had fully recognized until it was legally reviewed. And that is where the real identity shift happened, not in the courtroom, not in the family reactions, but in the realization that her silence had never been absence. It had been preparation. The family members who once labeled her as an outsider were now forced to confront a different truth: the system does not care about confidence, appearance, or narrative pressure. It only responds to verified structure. And once that structure is established, it does not bend back to opinion. It remains fixed. The billionaire mentor's final observation tied everything together in a way that felt less like advice and more like a summary of how the world actually works. People who understand money do not need to perform power. They build quiet systems that protect them when they are not in the room. They rely on ownership records instead of recognition. They trust cash flow history instead of reputation. They protect signatures because signatures determine authority. They read contracts when others rely on assumptions. They maintain discipline when others rely on pressure. And they let time, documentation, and legal structure do the work that emotion can never complete. The younger woman's journey, as seen through this estate dispute, was not about becoming powerful in the traditional sense. It was about becoming correctly recorded in a system that had initially misread her. And the correction was not dramatic, it was procedural. That is what made it irreversible. As the attorney closed the final version of the corrected estate file, the room no longer felt like a place of conflict. It felt like a place where reality had finally finished updating itself. And in that silence, the lesson remained without needing repetition: do not spend your life trying to look powerful, build a life where the truth, the records, and the assets can protect you when the room turns against you.